your child custody case. My name is Stacy, and I'm with Family Law Fighters. We're here to help you win your child custody case and your entire family law case. We assist with divorce, child custody, child support, restraining orders, and anything else related to child custody cases. What you're going to learn today is how to determine what you really want, how to maximize the actors and their motivations. So let's get started. First of all, you have to determine what you really want. And this is really important because all too often the family law process becomes something of a series of trying to bury your ex 6 feet underground rather than determining what kind of life you really want to live. So if you can determine what kind of life you want to live and work towards that end, then you're going to have a much more successful family law case. So if you can decide what you want, then you need to decide whether you can work with the other parent to come up with a parenting plan outside the court system. Now, I don't mean not doing anything, any paperwork or anything like that. What I really mean is, do you have to go to court? Do you have to use the mediators? Or can you and your ex sit down in your attorney's office and negotiate a settlement? Now, that's not always possible. And I'm going to give you some strategies today so that you can win when you do battle it out in court. But if you can sit down and negotiate it out and not have a judge make the final determination, you may find yourself feeling more successful about the end result. Remember, there are two ways to win. You can win through negotiation or you can win through litigation. And both are valid ways to win. So keep that in mind. It's not just winning when the judge hammers down the gavel. You can also win through having a successful negotiation. Now I want to talk about the different types of custody, because custody isn't a straightforward process. There's legal custody and there is physical custody. And it looks like my slides are a little behind, but they'll catch up in a minute here. I'm going to go ahead and keep talking. The legal custody is who makes the decisions regarding the health, welfare, and education of the children. There's joint legal custody and sole legal custody. Joint legal custody means that either parent can make the decision. Now, these are decisions regarding where the kids go to school, what religion the children are involved in, as well as little things like what kind of haircut they have or whether the kids get their ears pierced. Sole legal custody is more rare. This is when one parent has all the responsibility, and they may need to consult with the other ones if they have the final say. Physical custody, on the other hand, is the actual time that this parent spends with the child. This is either joint or sole, the same as legal. Now, joint is more typical. Now, joint does not necessarily mean 50-50 custody. What it means is that both parents spend a significant amount of time with the kids. It could mean 50-50, it could mean 80-20, it could mean 70-30, but it just means that both have a significant amount of time with the kid. The sole custody is more rare. This, again, does not mean that the parent not having sole custody never sees the kids, but what it does mean is that the sole custody person is responsible for the kids the majority of the time. And the advantage to having sole custody, the primary advantage, is that if you want to move away at any point, you have some additional standing in the law to do so. Lawyers toss around the terms primary and secondary physical custody a lot. These aren't actual terms in the code, but they get used a lot, so I'm going to go ahead and define them. Primary physical custody is the parent who has more than 50% timeshare, and secondary is the parent who has less than 50% timeshare. I want to say a word about 50-50 timeshare. This is something more and more parents are deciding to use, and it's perfectly acceptable. However, you should not call it 50-50. You should call it 51-49, and there's a very good reason for that. There's something in the tax code called the head of household exemption, And the parent who has more than 51% custody gets the head of household exemption, which is worth an awful lot of money on your taxes. So if you call it 50-50 custody, neither parent can take the tax exemption. So you want to call it 51-49. Now you can even alternate who gets the 51 and who gets the 49. So in odd years you could get it, and in the even years your ex could get it. But you want to alternate that so that, or you want to have that 51-49 so that somebody gets it, because there's no reason just to throw that away. Now, how do you go about determining custody, and how do you go about determining what it is you want in terms of custody? Well, there's some questions that you can ask yourself in terms of custody. It looks like my slides are a little behind again. First of all, ask yourself, how much time do you spend with your kids now? Are you the primary caretaker? Do you want to increase the amount of time you spend with your kids? And these three questions will lead you to determining what you want out of custody. Now, if you are the primary caretaker, consider that in the future, you're not going to have a support person in the house to relieve you. And so it might be nice to have somebody on the weekends or on an alternate weekend to take the kids so that you can date or have time with your friends, etc. If you are not the primary caretaker, if you're not the one who gets the kids up every morning and puts the kids to bed every night, consider how much responsibility this is and think about whether you are ready to take this kind of responsibility on, especially if you do not have a relief person in your house to help you. It can often be stressful to have the sole responsibility for children, and a lot of times parents underestimate how much stress that will be. The next thing you need to consider is the yearly schedule that you're going to plan out. First of all, take into account the kids' school schedule. Kids are governed by the rhythm of that September to June schedule, and that can change both over time, and sometimes they are in year-round school, sometimes they're in a more traditional schedule. Sometimes the school districts change from a September to June to an August to May schedule, and so you've got to be flexible both with the other parent and with the kids' school schedules. Another thing that happens along the same lines is the kids' sports schedules. Visitation doesn't make much sense to coincide with a kid's practices or games. So, you know, take those kinds of things into account. Another thing that you have to take into account is holidays. You're not going to spend every holiday with your kids anymore, and that's just a fact of life. And divvying up the holidays is something you're going to have to negotiate. One thing to take into account are the holidays that are important to you and not important to the other parent. For instance, Mother's Day and Father's Day should be spent with that parent and regularly scheduled visitation should not coincide with those days, so that mom doesn't have to spend Mother's Day alone and dad doesn't have to spend Father's Day alone. You should plan in vacations so that each parent can have some uninterrupted time, to go to grandma's house or to take a trip to Disney World. And finally, consider what your transportation schedule is like. This is really important because a lot of post-litigation conflict happens over transportation. What we have found is that the thing that minimizes the transportation hassles is for the receiving party to pick up. That is, the party who is going to see the kids does the picking up. That way, the party that is most anxious to see the kids is the one that picks up, and that way, the person who's dropping the kids off isn't late and cutting into the other person's time. It's just a suggestion, but it tends to make a lot of sense and tends to work well for the people who do it. So now we're going to talk about maximizing the chances of getting what you want. The first thing I'm going to suggest is that you stay on top of the paperwork. This is really key. Law is a paperwork-intensive process, and if you don't stay on top of the paperwork, you are going to be in a lot of trouble. First of all, you cannot win unless you file. Nothing happens till the papers get filed. So if you're putting it off, if you're thinking it doesn't matter, or that it's not something that's it's not something that you have to do, or that the other person will do it eventually, you need to just take the bulls by the horn and file. Next, you should know that where you file can matter. If the other if you and your ex do not live in the same county, the difference in counties does make a difference. For instance, different counties have different mediation processes, as we'll learn. And if you're in a confidential county and the other parent is in a non-confidential county, that can really impact how mediation goes. And I'll talk about that in a minute. Next, if the other parent lives out of state now, and you could be in a situation where if the other parent files and serves you first, you could be litigating in an entirely different state. And if the other parent lives in Texas, that could mean that you're having to fly to Texas all the time to go to court, and that could become a real pain. So filing first could be difficult. If the other parent lives out of state, you should also know that if they file, a whole new set of rules and regulations and laws apply. So the amount of child support you'll be getting or paying is different, and the timeshare is different, and everything I'm saying in this video is different depending on where you file. So what I'm telling you in this video only applies to California. The next thing is, if the other party files first, make sure you respond. You only have 30 days to respond to that petition and summons. So respond or lose your rights. On the other hand, if you file first and the other party fails to file, you can file what's called a default. And that means you can basically write your own orders. So that's a big advantage. Finally, use discovery to your advantage. There's basically 4 types of discovery. First of all, there are requests for production of documents. And this is where you can ask the other parent to submit virtually any documents you need to prove your case. And that can be a powerful tool. The next thing is interrogatories. And you can ask pretty much any questions you want of the other party. The next tool is a really powerful one, and it's underused, and that is requests for admissions. And these requests for admissions are what you use to ask the other parent to admit or deny certain facts. And you can ask the other parent to admit that they are not capable of being a primary caretaker. Now, most likely they will deny that, but if they fail to respond in the timely manner, then that is deemed admitted, and you can present that admission to the judge. And if they've admitted that they are not capable of being a primary caretaker, that's a slam dunk for you in a trial. And then the fourth thing is a deposition, and this is where you and your attorney and your ex sit down, and your attorney asks your ex and any questions that you come up with under oath with a court reporter present, and get them on the record, and you can use this testimony to impeach your ex at trial. Next, we're going to talk about knowing the actors in a case, because knowing the actors is very important. There's, of course, you and your ex, but other than that, there's attorneys, judges, mediators, 730 evaluators, and children's attorneys. So in terms of you and your ex, you will, of course, be a participant in the case, and your ex will probably be a participant in the case. If your ex chooses not to participate, he or she does not have to, and you can proceed without them. That's called proceeding by default. And you can talk to your attorney about how best to go about that. In California, you do not need to have the permission of the other party to get a divorce or to start a child custody action. This is a no-fault state, so you can do that all on your own. If the other party does participate, which they do in most cases, you can, then you'll need to engage them in the process and do the discovery and do all of that to get them involved. And your attorney can guide you through that process. So what can your attorney do for you? Well, first of all, you should know that you don't have to hire one, but there are some advantages. First of all, your attorney has done this before. They've gone to law school, they know the code, they know the statutes, they know the case law. They've done this thousands of times before in the case of the family law fighters, and they've seen thousands of cases, and they've got experience. Importantly, too, they're dispassionate. You have an emotional stake in this case. Your attorney does not. Your attorney wants to do the best job he or she can for you, but at the end of the day, they're going to go home to their family, and they're not going to take the emotions of the case with them. And that is so much of an advantage for you because they've got some perspective. Not only do they have some perspective on your case, they have some perspective on what works and what doesn't in all cases. So that's so much of an advantage to you. The next set of actors in a case are the judges. Now, it's important to note, many people, when they get a judge and the judge rules against them, say, I want a different judge. Well, you only have one chance to get a different judge, and that's before the judge has ever seen your case. So you must, if you've heard something about a judge that you don't like, you need to make your motion before that judge before you ever step foot in that courtroom, because that request to have the judge removed needs to happen before you go into the courtroom. If that judge sees you, you're stuck with him. So make sure that you know which judge you have and want him or her. Now, as a word of caution, if you object to a judge and you get a worse judge, you only get one chance to file what's called an affidavit of prejudice to get a judge off your case. So if you file an affidavit of prejudice and get a worse judge, well, you don't have any options then. So generally, the judges are pretty even-handed, and you're better off just going with the one you're assigned. But you do only have one chance to object to the judge, and that's before you go into court. Now, your attorney will be able to tell you what your particular judge is looking for. Some judges tend to be a little pro-mother or a little pro-father. Others tend to favor 50-50 custody over primary custody. Others are vice versa. So plan your strategy with your particular judge in mind. Now, before your judge ever sees your case, you're going to go to mandatory litigation, mediation. The only way out of mediation is to sit down and settle your case through negotiation outside of court. if you go to court, if you're going to have a court hearing on your case, you're going to have to go to mediation. So mediators are MSTs or social workers. They usually have a master's degree. They see 6 to 8 couples per day, and they don't have legal training. They have psychological training. They see you for about an hour. There's 2 kinds of counties in California. There's reporting and non-reporting counties. Reporting counties, like Orange County and Los Angeles, are really a forum for you and your ex to work things out. If you don't work things out, the mediator simply sends a report to the judge that no agreement was made. Therefore, in a mediating county or a non-reporting county, you can really open up and try and solve things. In reporting counties, on the other hand, these are counties like Riverside, San Bernardino, and San Diego. The mediator has more of a stake in getting you to work things out, because if you don't work things out, then he or she is going to submit a report to the judge on his or her opinion on what the outcome should be. This means that she is going to get more involved in the process of making recommendations throughout the negotiations. And your goal is different in reporting counties. Instead of just trying to work things out, your goal is to get the mediator on your side, because the mediator is acting like a quasi-judge. So, knowing that your goal is to get the mediator on your side, that's more important than solving anything in reporting counties. So knowing whether you have a reporting or a non-reporting county, that's one of my strongest pieces of advice in this webinar, is know what kind of mediation you have and know what the motivation of the mediator is, because that could have a huge outcome on what you do when you go into mediation. The judges rely, in reporting counties, the judges rely on these mediator reports very heavily to make their final determinations, and it's a big hurdle to overcome if the mediator's report's gone against you. So what do you do if the mediator report has gone against you? Well, one of my suggestions is to do what's called a 730 evaluation. Now, a 730 evaluation is done by a clinical psychologist who has a PhD or a PsyD in psychology. And a clinical psychologist sits down with all of the parties, and they do psychological exams. They interview all the parties, including the children if they're old enough. They look at all the documents of the case, and then they write a recommending report. And they see whether or not and then they do make the recommendation. And you can use a 730 evaluator to overcome a bad mediation report. But even in confidential counties, 730 evaluations can work in your favor if you think that an independent evaluator would be able to see all sides of the case and come out in your favor. Sometimes the 730 evaluator can see the pathologies in your ex and decide that you have the better case for custody. Now, the judges really rely on 730 evaluators because they've taken hours and hours and hours to look at the case. They're a neutral force, and they have clinical training. So judges really rely on these 730 evaluations. So if you can afford them, they're a good idea to get them. And if you think the 730 evaluation will be in your favor, they're a good idea to get them. Keep in mind that they cost money. Unlike mediation, which is basically included in the cost of your court filing, 730 evaluations cost usually in the neighborhood of $2,500 to $5,000, although we have seen them go as much as $10,000 in the past for particularly complex cases where additional witnesses are interviewed. So they can be expensive, and this is on top of your attorney's fees and your court filing fees and your deposition fees, and it all does add up. So they're not available to everybody, but if it is a tool that is in your price range, it can be a very powerful tool. Finally, I want to talk about children's attorneys. Now, again, children's attorneys are not used in every case. They are appointed by the court when it feels that the children's interests are being threatened by the actions of the parents. This could be when there are drugs involved in the case, drug use involved in the case, or when there's been allegations of sexual abuse, or simply when the parties are so acrimonious that the children's interests are getting lost. Now, the children's attorney represents the interests of the children based on what the child's attorney thinks is in the best interest of the child, but not based on the child's desires. So if a 12-year-old child says he wants to live with dad, but the attorney thinks that the child would be best served living with mom, the child will tell the court that the child wants to live with dad, but that the child would be best served living with mom. Sometimes the attorney will side with one parent. Other times the attorney will make recommendations that neither parent wants. The attorney is a full participant in the case. They can cross-examine witnesses, issue discovery, etc. Now, the court tends to take the children's attorney recommendations very seriously because it appointed the attorney and because the attorney is seen as a neutral party. In fact, the attorney is called the third hand of the court. So if you have a children's attorney in the case, it does complicate things. And usually parties tend to be unhappy when there's a children's attorney because the children's attorney isn't working for either side. So in conclusion, I just want to sum up where we've gone. We've talked about knowing the actors. It's very important to know the actors in the process, and importantly, what their objectives are. Because if you understand what the actors are, where the actors are coming from, that's key to getting what you want. Next, be on top of the paperwork. Know what the paperwork process is and stay on top of all filings. Use discovery sensibly. Finally, know what winning is. Understand that winning is not burying your ex 6 feet underground. Winning is building a life that you and your kids can thrive in. So thank you for watching this presentation of how to win your family law case. I'd like to invite you to come into our office for our 17-point child custody strategy session. Now, this strategy session is not a free consultation. Let me tell you what free consultations are. When an attorney offers a free consultation, basically he's saying, come into my office and let me sell you on my services. Rather, this 17-point strategy session is a carefully structured evaluation of where you are and where you're going with your case. After you're done with this hour-long session, you'll have a roadmap for how to litigate your child custody case. Your child custody case is probably the most important thing in your life right now. And $25 is a small price to pay to come away confident that you can have a handle on what you're doing. Normally, we charge $350 an hour for our time, but we're willing to lower our price to just $25 for this hour because we really, really want you to come in for this time. You'll be glad you came in. Your kids will be glad you came in. Now, maybe your ex won't be glad you came in, but you will be glad you came in. So click on the link below to schedule your appointment. It's easy to do, and we'll be ready for your appointment. Thanks again for watching. Our phone number is 714-220-8297. Schedule that appointment now. You'll be glad you did. Thanks. Bye. We'll see you soon.